Hey, y'all. Happy St. Patrick's Day. Wearing the green today. Hope you all are having a great evening. It's Friday, TGIF. I didn't get a chance to grab green beer, but I hope you did. We have a little bit to talk about tonight. We did a great deep dive on Wednesday. We did a 2-hour show, an hour on some of the other cases we've been covering, and an hour on Vallow Daybell. So we covered a lot of it, but we are going to get back into it. I want to say we had 580 people in our chat on Wednesday, so thank you all for joining us. We've had a lot of new viewers thanks to our appearance on Surviving the Survivor. So thanks again for that. And we're really excited. If you're new to the channel, thanks for joining us. My name is Lori Hellis. I am a retired criminal attorney, and I'm writing a book about the Vallow Daybell case. So I moved from Mesa, Arizona to Idaho to be close to the case. So I live in the Boyce area, and I will be attending the trial every day as long as I can get a seat. So we're going to talk tonight about what the court access is going to look like, and what Judge Boyce is going to allow and or not allow in terms of access to the courtroom. Judge Boyce has ordered that there will not be cameras in the courtroom. Audio files will be available in the evenings after the trial is done. So I'm just going to make a couple of announcements while we're waiting for a few people to join yet. First of all, happy St. Patrick's Day from our little dog. His name is Dobby, and he actually belongs to my mom. But since she moved into assisted living just down the block from us, he lives with us. So that's Dobby. I wanted to remind everybody that we're doing the True Crime Quilt Guild. You can see, whoops, helps if I click the right buttons. You can see behind me, let me tip my camera up a little bit, some of the blocks that I've been making for my version of the True Crime Quilt. So it's not too late to join. I am going to be getting the final videos out. What I've done is, this is a sampler quilt, means that there's several different block patterns that are there. And it's intended to help people learn. It's really a beginner's quilt. What I've done is done some instructional videos, which you'll find on our YouTube channel. They're also, the links are in our show notes. And the pattern's available on Etsy. It is not too late to join in. We do have working on getting a Facebook page up where everybody will be able to post their blocks and their finished quilts, because we want to be able to share all of those, all of that hard work that we've done. So if you are inclined, please join us. I should be getting the last 2 instructional videos out, I hope, this weekend. One showing the last block that we haven't learned how to do yet, and then, or last 2 blocks, and then a video on how to how to put all the blocks together and construct the quilt. You know, today is important because it's St. Patrick's Day, but for defense attorneys in particular, tomorrow is also a really kind of red letter day. Tomorrow is Gideon Day. This is Mr. Gideon. He was a prisoner who wrote, he read the Constitution and saw that the Constitution assured defendants the right to counsel. And so he hand wrote a petition to the United States Supreme Court in pencil and submitted it to the US Supreme Court. And in fact, that was the basis of Gideon versus Wainwright, or Wainwright versus Gideon. And Wainwright was the prison warden where he was located, where Mr. Gideon was located. And so he was the first person to put forth the argument that it was necessary for the court to appoint a lawyer for an indigent person. And I was just looking up to make sure I was had the right year. It's the 57th anniversary of Gideon versus Wainwright. It's an interesting read if you're interested in constitutional law or sort of gee whiz, that this man who lived in the South and was not an overly educated person was in prison and believed that he had been denied his rights to counsel because he couldn't afford a lawyer. And he made an argument to the U.S. Supreme Court, and they found in his favor. So that is the basis of what we call Miranda warnings. So that is Miranda versus Arizona, which was another case, a watershed case that determined that not only were you entitled to a court-appointed attorney, but you were entitled to a warning saying that you had the right to remain silent. Anything could be used, you said, could be used against you, and you had the right to an attorney. And if you couldn't afford one would be appointed. That was sort of the fusion in Miranda of saying not only do you have a right to a lawyer, but you have to be cautioned that you have a right to a lawyer and a right to remain silent before you're questioned. So it's a big deal. It's something perhaps these days we take for granted, but certainly Mr. Gideon didn't take it for granted. So I have one more announcement. I am also going to put this in the newsletter, but for those of you who are in the Boise area, we're going to have a meet and greet, and it's going to happen on April 4th, which is the second day of jury selection for the Vallow-Daybell trial. And we are hoping to invite some special guests who might be in town for the trial. So this is a great opportunity to get together. It's just very casual. It's a pizza place, and it's a great chance for everybody to get together, to meet other like-minded people, other people who are interested in the case and who are following. And so I'll be putting this out in the newsletter, and we'll be publicizing it. But for now, if you happen to be in the Boise area, this will be in Meridian, which is a little community right next to Boise, sort of a Boise suburb, if that's a thing. And so we're hoping lots of people are going to come and join us for pizza, have a beer, meet some of your friends, some other people in the area who might be interested in the case as well. So let's talk about court access, since we're now talking about the case. Now, for those of you who tuned in on Wednesday, this may seem a little redundant, but I am going to repeat it because I think it bears repeating. Judge Boyce has decided that there will be no cameras in the courtroom. The only access will be if you are in person. In person includes a live closed circuit link to an overflow room in the courthouse in Ada County here in Boise, as well as a live link to the courtroom for the folks who are in Madison and Fremont counties. So there will be a viewing room where it will be live broadcast into the Madison County Courthouse in Rexburg, as well as an overflow room in the Ada County Courthouse. So what we were told when we attended a Zoom media conference earlier this week, we were told there's about 75 seats in the courtroom. Now, some of those are going to be set aside for family, as well as Nate Eaton has asked the court to permit a sketch artist, and it's a pool sketch artist. So several different media outlets have gone together to hire this sketch artist and to use whatever that person produces. And Nate Eaton has asked for there to be a seat, a reserved seat set aside for that sketch artist every day. What will happen is, the interesting thing is that Judge Boyce has not made any special provisions for the media. So media credentials don't do you a bit of good. You end up having to get online into their reservation portal and make a reservation for the trial. And you have to be able to produce proof that you have a reservation for a seat in the trial. So the seats in the courtroom will be reserved first. The reservations will activate at 8 o'clock on the business day prior. So for example, if you want to go on Monday at 8 a.m. on Friday, you have to get on the portal and get in the queue and get your request in for a reserved seat. If you don't get a seat in the courtroom, there's still about 175 seats in an overflow room. The trial will be closed circuit broadcast into that room. Now, that live stream broadcast will not be saved or stored. It is contemporaneous with the trial. There is no way to recover that or to get it later. The only thing that people are going to be able to get later is the daily audio recording. For those of you who followed Nate Eaton and who've seen what he's done for the previous hearings, where the hearing happens and as soon as the clerk releases the audio, he gets it posted on his YouTube channel. We understand that the recordings are going to cost around $90 to $100 a day for that 8 to 10 week trial. The court is still anticipating, even though the trial has been severed, that the case will take 8 to 10 weeks. So that ends up being an awful lot of money. There were quite a few creators who were interested, like Nate did with the sketch artist, going together to get the recordings. However, Nate Eaton has announced that he and East Idaho News are going to be obtaining that recording daily and posting it both on his YouTube channel and his website. Very generous of East Idaho News to do that. For those of you who follow the case closely, you know about Nate, you know that he has been closely involved with the case from the very beginning. East Idaho News is located, their headquarters is in Idaho Falls, which is very close to Rexburg, really probably the outlet for news. They're an online news service, but they've done a great job of covering the case from day one. So that is the audios are going to be posted on his website and YouTube channel. There will be not be photos. Several people asked whether or not there would be opportunities to catch video of Lori leaving and coming and going from the courtroom. The court staff said they didn't believe that would be the case. So if news organizations want BRoll, they're going to have to dig for it. BRoll, that's that stuff they play while they're talking over the top of it. So that is the way access to the court is going to go. I know there are a lot of people who are incredibly frustrated about this and have asked, many more people than one have asked me, isn't there some recourse? Can't we appeal to a higher authority. Well, I've looked at the statute and the law in Idaho, the statute that covers access, camera access, media access to a trial, specifically says it is completely up to the trial judge, and their decision is not appealable. So there is no higher authority to go to now that Judge Boyce has said no cameras in the courtroom. Now, it may be that part of that calculus for him was the idea that Chad Daybell's still going to have a trial coming up. We think maybe toward the end of this year. And that Judge Boyce, was trying to be cautious about not tainting the jury pool any more than it will be by Lori's trial happening first. I don't know that that's really true, but I think that may have factored into his decision. I guess my point of view on it is people's memories can be kind of short. We're a little bit like guppies, we have 3-second attention spans. So it's possible that by the time Chad's case came to trial, any furor over Lori's case would have died down. Anything that comes out in the public trial, the media is going to have access to, and they're going to be able to talk about when it comes time for Chad's trial. So it wouldn't surprise me if Judge Boyce changes his position once Chad's case comes to trial. I don't know. But to this point, he has been very clear about the fact that he has no intention of allowing cameras in the courtroom. So that's where we are. There have been several motions. We had a motion hearing on Monday, I think. The days have been all running together for me recently, but no, actually, I think it was Tuesday. We had a motion hearing, and there was a conversation about the pending motions, which were a defense motion for a motion in limine, and a defense motion to take the death penalty off the table because of the discovery violations, and a motion to compel. So we talked about it at length on our Wednesday show. I also talked about it at length in the newsletter. So anybody who wants to take a really deep dive into that, that's where to look. But I think it's important to point out, for those who might just be joining us now or didn't tune into Wednesday, that there are some significant issues surrounding discovery. The discovery process should be in a case, especially a case of this magnitude, but any criminal case, should be a very straightforward, very streamlined process, because the prosecutor's office does it every day and defense attorneys know what to expect. That has not been the case in this case. The discovery in this case is preceded by fits and starts. Some information was released in the earlier cases, early charges. Those cases have now been dismissed. And there's been an awful lot of wrangling going back and forth about discovery. And issues about discovery go clear back to Mark Means. Go clear back to Mark Means and John Pryor asking for discovery and complaining about not getting it. So I think that the prosecution has been on notice for a very long time that discovery was an issue. But it has only been in the last maybe 4 to 6 weeks that we've seen the prosecution going back and really taking a hard look at making sure that all the discovery has been produced. And when that happens, when you do that, you put it off until the last minute, lo and behold, you discover a bunch of stuff that you did not turn over. One of the most significant things that was not turned over. Now, we know about this newly discovered DNA. So just to do a little quick review, because there's a lot of moving parts to this case, and it's easy to forget some of this stuff or easy to lose sight of it. So I'm going to do a little quick review. Early in the case, while Lori was still in state hospital, the prosecution notified the defense that there were two forensic samples that were very small and that likely testing them for DNA would completely consume the sample. Now, what usually happens when you take a forensic sample is that you parse out that sample so that you have some left over in case the defense decides that they want to have an independent lab test. It also is important because if the Supreme Court throws a case out or orders a case to be retried, then you still have the opportunity to go back and reconstruct your case based on the fact that you have this spare discovery or spare sample. So out of an abundance of caution, most prosecutors try really hard to preserve some of a forensic sample. But what happens sometimes is that you have a sample that is so tiny that there's not enough to do that, and you end up consuming the entire sample in order to complete the test. So the prosecution notified the defense back while Lori was still in the state hospital, that they had these two samples that they needed to come to some agreement on how they were going to be tested because they only got one shot at the test. So the defense said, hold on, we want to do more investigation. We don't want you to test and use up the sample. The prosecution said, we don't want to have the sample tested because Lori is incompetent and her portion of the case has stayed. We don't want her to be able to come back and say, oh, hold on, I wouldn't have agreed to consume that sample had I had a voice. But at the time, her case was stayed, so she didn't really have a voice in the matter. So it all got delayed until Lori was found competent and rejoined the case. So that was last spring. And after that, it took a while for the attorneys to finally come to an agreement on how they were going to treat that. I'm just turning off my other screen here. How they were going to treat those samples. So they came to an agreement. The prosecutor sent them out for testing over the period of time, and Lindsay Blake talks a bit about this in one of the last couple hearings, that they initially sent the samples out to a private lab, and they was back east, and they had to get them back. And anyway, it took a substantial amount of time to get those samples tested. So right around Thanksgiving, I think, they finally got those requests, those samples, the tests done on those samples and the results back. But what happened was, while the samples were being prepared for testing at the state lab found two hairs in the duct tape that they were working with. Now, this is not at all unusual because duct tape is sticky and it sticks to everything. And there could be lots of DNA, lots of hair, lots of other things in duct tape that have nothing to do with the case, especially if it's an old roll of duct tape. However, the state and the defense both said we need to test these two newly recovered hairs. They also are small enough samples that the state lab wasn't sure that they would be able to pull any DNA off of them, and which leads me to believe they might be body hairs. They also were concerned that they wouldn't be able to do it in a timely way. And since they're such small samples, we're only going to get one shot. So the prosecution notified the defense at Christmas, I want to say day after or day before Christmas, about these two samples. And the prosecution then sent the samples to a specialty lab that assured them that they could do it fast and they would be able to raise DNA out of these small samples. So the first thing we have this new DNA evidence. When the DNA report comes back, it comes back that the DNA identified in those two new hairs is unidentified. Doesn't identify to anybody, any of the defendants. Doesn't identify to Alex Cox, who is a known or a unindicted co-conspirator, basically, because he's deceased. Doesn't come back to any of those people. So now here's the dilemma. We don't know whose DNA that is. And they can start doing some genealogical reconstruction and see if they can identify whose DNA that is. But that was not going to be gotten done before trial. The next thing that happened was that as the prosecution is going through all of their records, they discover that they have not turned over, even though they were asked for. And I do recall there being a lot of conversation early in this case, a year ago, about FBI interviews. So what happened was the FBI interviewed witnesses and then did follow-up interviews. So the defense was given the initial reports for those FBI interviews, but not the actual recordings. So oftentimes when an officer does an interview, they sit down, take notes, write up a report that is their interpretation of the interview. But you also should get the raw recording. So what happened was the defense only got the reports and no raw recordings. And then they knew that there had been follow-up interviews because their investigator had attempted to get in touch with a couple of these witnesses and been told, oh, we've already met again with the FBI, or she's out of town because she's meeting with the FBI. So the defense knew that the FBI was conducting follow-up interviews, and the defense never got any reports, any recordings of those. So, and they've asked for them. I remember the hearings when they were complaining about that. Now we get to the point where we're a mere few days from the trial, and the prosecution says, oh yeah, well, we just stumbled across those and here they are. And so you have, I don't know, 30, 40, 50 hours of interviews that need to be culled through to make sure there's no significant information in them. And probably the biggest one is the issue of jail phone calls. Now, we all know, you know from the Murdaugh case, you know from this case, jail calls and jail visits are recorded. Now, what's interesting is that in the Fremont County Jail, in-person visits are recorded, but if they're not requested right away, the system writes over them. So a lot of those in-person jail meetings have been lost. But there's 3,000 jail telephone calls that they didn't turn over. The prosecution said to the defense knew that it was a possibility, requested them specifically, was told, oh yeah, if there are any, we'll get them to you by July of 2021, and they were never produced. And so now at midnight, practically on the eve of trial, the prosecution's handed over 3,000 jail calls. Well, there's no way that they can review all those calls. And there's physically not enough hours between now and the time the trial starts. You have to ask yourself why this is happening. you have to ask yourself whether um, in the $3.6 million that the state has spent on this trial that hasn't even gone to trial yet, if there should have been someone hired whose job was to manage all of this, what everyone admits is voluminous discovery. You've got to ask yourself, why wasn't there one person whose only job it was to organize and follow up on all of this evidence and make sure that it was turned over in a timely manner? Because now what is being asked is that Judge Boyce do one of several things as a remedy for the fact that the state hasn't, or the defense hasn't had time to get ready this evidence for trial. The first one is that they have asked for the death penalty to be taken off the table. What was interesting during the hearing was that Judge Boyce clearly had done some of his own research, because he looked at them and said, here are these federal cases that specifically say that the death penalty can be taken off the table, can be dismissed because of discovery violations. And I'm not sure that the prosecution answered that question to Judge Boyce's satisfaction. Now, Judge Boyce is going to make a decision about these motions next week on the 22nd. That is cutting it very, very close to the beginning of trial. We understand there is a transport order, and Lori is to be transported from Madison County, where she is being held, to Ada County, somewhere around the 25th of March. They are not, for obvious security reasons, releasing any information about exactly when her transfer will happen, but she will be transferred to Ada County. If she is found not guilty, she'll be released from Ada County. If she is found guilty, she will remain in Ada County through the penalty phase. Once she is sentenced, she will go directly to state corrections. So she will not be going back to Madison County or to Fremont County. She's in Madison County because Fremont County doesn't have jail, doesn't have cells for women. And so they rent space from the neighboring Madison County jail. So I know that lots of people have lots of questions, so I think we'll go ahead and open it up for questions and see what y'all want to talk about. There is a case I have been starting to tune in on, and I'm hoping that we'll have a chance to have a conversation about it next week on Wednesday. And it's kind of an interesting case. We've talked before about the fact that I'm just pulling it up so that everybody, so that I can tell everybody about it. And I want to get the guy's name right. His name is Zechariah Anderson. And it's a Wisconsin case. It's going on now. The judge in the case seems competent, but really slow talking. He's a little hard to listen to. I've found it interesting because it has some really interesting legal issues in it, although they might be a little bit esoteric for folks, but I found it interesting. He is accused of, he and his, I don't know that they were ever married, but longtime girlfriend, they had children together. He had been very controlling. She broke up with him, started dating, was dating another guy. And the prosecution's theory, so she goes to the new boyfriend's house, and his apartment there's blood everywhere, but no body. but clearly enough blood that it's clear someone died there. And but no body. And she calls the police come, there's this big investigation, and as a result, they arrest her ex. And he claims he didn't do it. He's been set up, and he claims she set him up. So it's a pretty interesting case. So we can talk a little bit more about that on Wednesday. Good question, Susie Yay. And thank you so much for your donation. I'm telling you what, you guys are so generous. We had a lot of new super chats last week or on Wednesday. And I want you to know how much I appreciate that, because from the very beginning, when we started this YouTube channel, it has been my commitment to pass all of those super chats and all of those donations through PayPal directly through to our moderators, and it's made a huge difference for them. So I thank you so much. Susie Gay, this is a good question. How does the court produce the tapes? Are they physical or digital? Also, any possibility that High Demand could get Boyce to at least stream audio? You know, I don't know. I know that there was a petition that that people were signing. I know that Kay and Larry asked for all of the creators to send a plea out to followers, asking them to write letters to Judge Boyce. We include Judge Boyce's address and the case numbers in the show notes so that anybody who wants to do that can. But Judge Boyce has sort of been very clear that that was his boundary. So I don't know that inundating him with any more demands is going to help him change his mind. As to the recordings, at this point, the court has said they will put that recording either on disk or on thumb drive for anybody to pick up. They also were exploring a way to offer a digital download through a portal. So I know that Nate Eaton either way has said it doesn't matter. As the pretrial hearings have happened, I know that they've all been given to them on a thumb drive, and Nate sends somebody to courthouse to pick them up. So, and I'm sure that that will continue to be the what he'll do if that's needed. Now, a lot of times courts now have a download service, and anybody who pays for access to the audio gets a password or a passcode, and then can go onto the portal and download what they need. So I'm kind of hoping that Ada County might get there, but as it stands right now, people who want the recordings will be required to go and physically pick it up. And I don't know at this point if the trial goes all the way until 5 o'clock. I'm hoping that those recordings are going to be available at 5 o'clock, but it's a little hard to tell at this point. Oh, this is a good question. Hi, Polio. I want to talk a little bit about mistrial versus retrial, because I think this is that it's a common confusion. So a mistrial is a very particular issue. And it has to do with either purposeful or inadvertent information being transmitted to a jury that shouldn't have been. So the only time you get a mistrial is when a jury's seated already. Um, a- Actually, the Zechariah Anderson case, there is an issue. An issue came up early on. And again, it's sort of a technical legal issue, but it led the prosecutor to ask the court for a mistrial because he felt that the defense had presented in their opening statement information that was going to be prejudicial and that should not have been presented to the jury. So the judge then had to decide whether or not that particular piece of information warranted a mistrial. He ruled against calling for a mistrial, but that's the situation where a mistrial comes into play. Either a intentional or accidental release of information to a jury that the jury should not be considering. A retrial happens when the trial happens, the person is convicted, they appeal to the appellate court, and the appeals court, in this case, it will be the Idaho Supreme Court because they are the court that reviews death penalty cases. So the Idaho Supreme Court would come back and say, Ms. Vallow is entitled to a new trial. At a new trial, she will be entitled to get all of that discovery that wasn't available to her at her first trial. So the other question is, if Judge Boyce takes the death penalty off the table in a retrial, can the death penalty come back? No, because if the Idaho Supreme Court says she's entitled to a new trial, they can't pursue the death penalty for a second time. It would be a new trial on the charges as they were in the original trial. So the charging instrument, the indictment, those charges would be the same. And the notice of death penalty is considered to be part of those charges. If the judge were to dismiss the death penalty or were to dismiss one or more of the individual charges and say, I don't believe there's a basis for this charge of, I don't believe that she was involved in the conspiracy to kill Tammy. And so I'm going to dismiss that charge. Then it couldn't come back if the Supreme Court then granted her a retrial. Hopefully that makes sense. The death penalty is considered to be part of the charging document or the charging decision. So whatever she was tried on initially would be the charges she would be, and the potential penalty she would be tried on the second time. So, hi, Compassionate RN. I love that name, but I have to say, every RN I've ever met in my life is a compassionate RN. And it takes a special kind of person to do that job. It's not me. I'm not that person, but and it makes me appreciate even more folks who are. Question: wouldn't Lori have a better argument for dismissal appeal based on speedy trial because the court used joint trial as a reason for continuance and then severed? That's a good question. So maybe, but looking factually at how this all played out, there were about 6 weeks that her case was stayed because of the back in late September, early October of last year, 2022, her attorneys once again raised the issue of whether or not she was competent. And there was a period of, I want to say, about 6 weeks where her case was stayed. When her lawyers raised the issue of her competency, the trial was set for January, which was within her speedy trial window. But what came up was that the judge vacated that January date because of their request for a competency review. As it turned out, they probably could have kept that January date because she was found to be competent. But because the judge had vacated it, he had to go back to Ada County and ask Ada County to reschedule the trial. And April was the earliest point at which the trial could be rescheduled. So I think there's an argument to be made that although often in speedy trial cases, you'll hear them say, well, if the delay is attributable to the defense, then they don't get to, it's as if they waived it. In the case where you have a client who has competency issues and the court suspends the case while the competency issues play out, it's sort of semi-attributable to them, but it doesn't waive their right to speedy trial. They don't get penalized for raising the competency issue, but the prosecution doesn't get penalized either because the case isn't going forward because of the competency issues. So I don't know. I think probably the Supreme Court would say, yeah, okay, you're 40 odd days past your speedy trial deadline, but some of that has to be attributable to you because your competence was at issue, and that's what delayed the January trial that was actually still within the window. I sort of doubt that at this point, a speedy trial, a dismissal because of the speedy trial issue would fly. I think they're right on the kind of on the wire there, and I think any further delays for Lori would be fatal. And that's why the judge had to sever the case. So I hope that makes sense. It's clear. A Southern point of view. Thanks again for your super chat. Do you think Lori Chad talked through lawyers and intentionally caused the sever? Pryor demanded his trial last year, then fought to continue to cause a severance. I don't know that Chad and Lori are talking through their lawyers. There's no question that John Pryor, I mean, they do communicate through their lawyers. They talk to their lawyers and the lawyers talk to each other. So there is some sort of third-hand communication going on. But John Pryor was clear from the beginning that he wanted these cases severed. It is not at all unusual for a defense attorney to say, we're ready, we'll go to trial, because they're going to try and put the prosecution, their case to the test. They're going to hold their feet to the fire. It's not at all that unusual. It's also not unusual, as they get a look at the tremendous amount of discovery in the case, to suddenly say, well, hold on, I need more time. So, I don't think it's all that surprising. You're right. John Pryor did demand trial last year. And I think that if the court and the prosecution had called his bluff, he would have had to try the case. And all he can say is, I'm going to be as ready as I possibly can on the date the court sets. So a lot of the issues had to do with the fact that that there was discovery, there was testing that hadn't been completed. And the reason for the delay, when John Pryor said, I'm ready to go and I'll be ready to go in October of last year, The prosecution was the one who asked for more time because they hadn't completed all that DNA testing we just talked about. That was all still pending. And so they asked for more time to get all of their evidentiary testing done. And then, of course, we had the issue of Lori's competency, and that impacted the January date. So I agree. John Pryor asked for his trial last year, and I think it is a common defense tactic to say, hey, I'll try the case anywhere, anytime, anyhow. Let's go. Because then the prosecution really has to. I know we've heard from Scott Reich before. Scott and I have had this conversation. The prosecution should be ready on day one when they bring the charges to try the case. You shouldn't charge a case that you're not ready to try tomorrow. But that's not the reality of the way it works. Oftentimes, the prosecution develops enough evidence to meet the probable cause threshold of a preliminary hearing or a grand jury, and they continue to investigate as the case goes on. That's more the reality of the way these cases unfold. So even though the case was charged and had been pending for ever, months, years, the reality is that I think the prosecution was still investigating. I believe John Pryor thought that, and I think that was his way of trying to hold their feet to the fire and press forward. He's got a client that's in custody, so you can't blame somebody for saying, I want to just go forward and have this decided once and for all and not be left hanging, trying to figure out whether I can get out of jail or not. So, good question, though. We had a sunny day today in the high 40s and windy, and I can certainly tell, you can hear it, that things are starting to bloom around here. So, sorry for the rasp. Hi, Derek Parker. Several of the prior hearings audio released to the public had missing audio of some portions of the hearing. How confident are you the trial audio will be accurate? Well, that's a really good question. Several of those recordings, what we know about the way that Fremont County's courtroom is set up is there is a microphone on each counsel table. There is a microphone at a podium, and there is a microphone in the witness box and one in front of the judge. That makes picking up on the courtroom recording system difficult. I think everyone is hoping that Ada County's sound system is going to be better, because we've seen several instances where either the mic wasn't turned on. We had one whole recording where you couldn't hear Lindsay Blake because the mic on her desk wasn't turned on. And we often hear one of the attorneys fade in and out because they're too far away from the microphone. Now, at the Murdoch case, to get back to that one, they did a really good job with the sound, because people were walking around the courtroom and they were still getting picked up on the at least on the live stream audio. There were times that the judge was reminding people to speak into the microphone for the recording system. So I'm hoping that Ada County is going to be better about addressing that issue and making sure that the sound, the recordings the microphones are adequate to capture the recordings in the trial. That was the benefit in Murdoch of having a court TV, or whoever the pool videographers were, of having them provide that commercial equipment, because they did a good job of capturing all that stuff when people were walking around the courtroom. So how confident am I? I hope that Ada County is going to be better equipped than Fremont County. Oh, you can buy me a coffee. One of my followers, you out there, asked why I wasn't signed up on Buy Me a Coffee. So I did, and lots of people have very kindly bought me coffee. I think I'm good for coffee all the way till the trial starts. So thanks so much. It's been fun to give everybody a chance to do that, and fun to see all your comments. I wish I could sit and meet with every one of you and have coffee, but it's a little bit of a chance to visit about it. Gritty Gret. Question: wasn't the defense aware the FBI recordings weren't provided by prosecution before March? Yep. Well, here that was the prosecution's argument, was they knew they existed and they should have told us we didn't have them. So it's more difficult to prove a negative. And the way that discovery works, is that it is not the responsibility of the defense to figure out what they don't have, because that's sometimes really hard. Now, in this case, they knew that there were these additional FBI recordings and had actually requested them. And they had been told, you'll get them when we get them. But the prosecution has a responsibility. And here, let's talk about the mechanical part of this, and maybe this will make a little more sense. The defense cannot go directly to the person, the entity that has the evidence. So, for example, the defense can't go to the FBI directly and say, I know that you have recordings of these interviews and I want them. The defense has to go to the prosecution and say to the prosecution, I think there are FBI recordings out there I don't have. And then the prosecution has to go to the entity and get that information. The defense cannot go to the crime lab and say, give me the report, the DNA report. That DNA report has to be sent to the prosecution, and then the prosecution has to provide it to the defense. So because of that setup, the only access the defense has is through the prosecution. The prosecution has this heightened responsibility to make sure that they have turned everything over and that they are responsible. So we heard a lot in the last hearing about Jim Archibald complaining that they were trying to shift the burden, the responsibility off of them and to the defense, that the defense had the responsibility to ask for them or to tell them we don't have it. Well, I mean, sometimes it's a case of we don't know what we don't know. And because of that imbalance in the power of who's got control of the discovery, the prosecution has a heightened responsibility to provide that discovery. It isn't, even if the defense knows that those FBI tapes are out there, it's not their responsibility to bang on the prosecution's door until they provide them. Now, my recollection is that back probably a year ago, John Pryor was asking, where are these FBI tapes? And was told, we'll get them to you when we get them. But the prosecution never took the second necessary step of going back to the FBI and saying, where are all these tapes? Those interviews were completed a long time ago. So it really, I know the prosecution made a big point of saying, well, you knew they were out there. You should have asked us for them. You should have told us you didn't have them. But legally, they're not required. It's not their responsibility and their burden, as we say. So, hi, Beth Riggenbach. Could the AG get involved and take over due to the discovery issues? No. The only way the AG can take over is if the county prosecutor asks them into the case. And the problem with that was, from the beginning, that the AG's office said it's all or nothing. Either you give us the case or you keep the case. But Rob Wood, you can't continue to work on the case if we take it over. So some of you may recall that in Fremont County prosecutor was a woman named Marsha Murdoch. She decided not to run again. She was the prosecutor at the time that Tammy Daybell died, and before the bodies of the children were found in Fremont County. So she was concerned that Fremont County didn't have the resources to properly investigate and potentially prosecute Tammy Daybell's death, and she asked the AG to come in. She decided not to run for re-election. Lindsay Blake, who was a hometown girl, grew up in Fremont County, had been in Utah practicing and moved back to Fremont County, ran for prosecutor and won. One of her first acts was during the campaign, in the interim, the children's bodies had been found in Fremont County. Rob Wood had been appointed special prosecutor so that he was working with her in Fremont County. And one of the first things she did was to ask for the Tammy Daybell's case back. So the only way the AG gets involved is if the local county requests it. It's the same with the state law enforcement agencies. So the Idaho State Police in this case, SLED down in North Carolina on the Murdoch case, or South Carolina, the only way that those law enforcement agencies get into a case is when they're invited by local law enforcement. Same with the FBI. The FBI can't come in and do an investigation. They come in to help out. But unless it's a federal crime, they're not the primary investigators on the case. There's always a local agency that's the primary investigator. So yeah, the AG can't take over unless they ask them to. And I don't think Rob Wood was going to do that. I don't think Lindsay Blake was going to do it because they felt an obligation to keep the case in their county. Wow, I thought we weren't going to have a huge amount to talk about because we haven't had any real new developments in the case, but we've had some great questions. We didn't see Trisha the trucker tonight, so I wonder where she is. It's always interesting to see where she's laying her head. She's always on the road. Once again, I want to thank everybody for joining us tonight. I want to point out that we have had 300 new subscriptions in the last 28 days to the YouTube channel. So I want to say thanks to all of you who are joining us and have discovered us. A lot, in fact, because of my joint appearance with Gigi McKelvey from Pretty Lies and Alibis on Surviving the Survivor. They were very gracious and have said that they would love to have us back and that we might, they might be asking us to come back once the trial gets underway. Don't forget, we're going to have a pizza party on April 4th. And I definitely, if you are in the area, I want to see your face and we're going to drink a beer together. I think it's going to be a great fun, and we are hoping that we're going to be able to include some special guests that are going to be in town for the trial. So I'm hoping that you all, everybody who can, will join us. And please, Michelle just posted, if we didn't get to your question tonight, please post them in the comments because I go back the next day with a cup of coffee, my gallon of coffee, and go through them all. I read all the chats and I check all of the comments and the questions. If for some reason you have a question that you don't feel comfortable sticking in the comments and then in the chat, email me. The email is in our show notes, And you can email me directly, and I respond to every one of them. Sometimes it takes me a little while, but I do answer them all. Thanks again for joining us. We always want to recognize that you could be spending your Friday night a lot of other places besides here. I want to wish everybody a happy and safe St. Patrick's Day. Happy St. Patrick's Day to all you Irish, or I think everybody's Irish on St. Patrick's Day, even the Portuguese. So I'm going to say good night. Everybody have a great weekend. We'll see you again on Wednesday. I'm sure there'll be plenty to talk about, including the next hearing that's coming up on the 22nd. So stick with us as we get ready to rumble. We get ready for trial. Thanks again and good night.